Okay, in this video I want to just discuss something that I've noticed recently with small employers. So if you're a small employer, this video should be of some benefit to you, and it might even provide you with some comfort. Recently I've come across a number of situations where a small employer has got into all sorts of difficulty with an employment law claim or an alleged employment law claim as a result of basically not getting good advice at the outset or not getting any advice at all, and basically being put under quite a lot of anxiety and stress and panic as a result of not understanding exactly what they were facing. Let me give you 3 examples, and these are 3 real employers, 3 real cases. The first one involves an unfair dismissal claim. The unfair dismissal claim was put in by the employee. The employee had been terminated from the employment and put in an unfair dismissal claim to the Workplace Relations Commission. In due course then a letter came out from the WRC, as it normally does, to the employer, and the employer immediately panicked and looked at the unfair dismissal claim and did a bit of research himself or herself, can't remember which, it was a husband and wife team, and discovered that an unfair dismissal can lead to an award of up to 2 years' salary. And this caused a huge amount of stress and worry for the employer, small employers. When they sent me the Workplace Relations Commission complaint form though, and I always ask to see the actual complaint that the employee has sent in, when I looked at it closely, I discovered that the employee was only out of work for about a month. In other words, he had successfully obtained new employment about a month later. This means that even if the employer loses the case, the likely award for the employee is going to be 1 month's salary. Now, the employee was working in a factory or a warehouse or somewhere like that and wasn't very well paid, and therefore 1 month's salary was going to be fairly small. So the employer quite possibly could have looked at the situation and said, look, we'll go and fight this case or defend it, and if we lose, the most we're going to lose is a month's salary. On the other hand, they could have said, we won't fight it, we'll just let him go ahead, or we'll try and settle with them and we'll offer him a month's salary or 3 weeks salary or whatever. But the bottom line is that this particular claim caused a huge amount of stress and annoyance and worry for the employer in circumstances where the actual outcome wouldn't have been or couldn't have been too bad, because the maximum that could have been awarded was a month's salary, and the problem was the employer hadn't got good advice at the outset and had gone off then and had simply looked up the legislation, looked up on Google or wherever that you can get 2 years salary for an unfair dismissal claim. A lot of needless and avoidable stress and anxiety could have been avoided with some half-decent advice at the outset, and the employer obviously, would have slept better. Second case involved another small company where essentially a small employer, a claim came in from a gentleman who had been working with the employer for many, many years, and at the end of it all, he went to a solicitor and was bringing a whole series of claims against his former employer. Now, it so happened that the employee in question had been working for a long period of time, was on relatively small money, and was getting close to retirement. And he went to the solicitor wrote a letter to the employer came to me, and when I looked at the letter, it contained a whole lot of claims or potential claims arising from the employment, including stress, including breach of contract, including non-payment of wages, including non-payment of minimum wage, including public holiday entitlements not being granted, including annual leave not being granted, and so forth. Again, this caused a huge amount of distress and anxiety for the employer. The bottom line is that if you actually had a look at the specific claims that he was bringing and broke them down and looked at the constituent parts, you would have recognised that firstly, in relation to the personal injury claim, for example, or the stress claim. I mean, in order to win a stress claim, you must prove that you've suffered an identifiable or recognisable psychiatric or psychological injury as a result of the negligence of the employer. To win that sort of a case, you need to prove a number of things. You need to prove that you have suffered a recognised injury. You need to prove that that injury was caused by the negligence of the employer. You need to prove that it was foreseeable you were going to suffer an injury, and you must prove that the employer did not act as a reasonable employer would do. It, quite frankly, is a difficult case to win, and the first step in it is to go to the Injuries Board and bring a claim there. The Injuries Board will then hand it off, not touch it with a barge pole because it's psychological or psychiatric, give you a letter to bring legal proceedings into courts, and then you go to the courts, you issue a summons, you have it served on the other side, and eventually you might have a legal case or a legal claim, a personal injury claim, personal injury proceedings, which could go on for like 2, 3, 4 years. So, talking about stress is one thing, but actually proving a case based on a psychological or psychiatric injury, a stress-based claim, is difficult. Therefore, that particular part of the claim, the letter that came in to the small employer, you could probably, quite frankly, disregard it, because unless he had very strong proofs, it's not enough just to say I was stressed as a result of working there or whatever. The other claims then to do with payment of wages, annual leave, public holidays. Remember, all of these claims are statutory based claims. They must be brought within 6 months of the alleged transgression, and therefore if anything that's outside 6 months cannot be dealt with by the WRC. Therefore, these claims, they were relatively small to begin with, and the WRC, if the claim was brought there in the first instance, could only deal with the previous 6 months. So again, there's a very, very limited exposure for the small employer in respect of these particular claims. And again, this person was caused significant amount of anxiety and worry as a result of the claim or the letter that came in from the solicitor representing the employee. And thirdly, it involved a situation where a trade union sent in a letter on behalf of an employee. The employee had a number of grievances. The grievances, he wanted a meeting, or the trade union wanted a meeting along with the employee, with the owners of this small business, a small employer, a small number of employees. They, having received this letter from the trade union in question, tried to do the right thing, agreed to a meeting with the trade union representative and the employee to try to resolve the issues. Went through a number of meetings then, and there was toing and froing, and there was various meetings arranged. There was minutes drawn up and issued. There was witnesses and note takers, and at the end of the day, the issues, the grievances, were not resolved. And this was after a considerable amount of time spent by the employer in trying to resolve the problem and trying to satisfy the employee. The bottom line is then that the trade union on behalf of the employee submitted a claim to the WRC. This claim then, a letter arose or came out again, as I've said at the beginning of the video, came out from the WRC to the employer. The employer then, of course, crapped himself, quite frankly, having received a letter from the WRC and never having received one before, and again was stressed and anxious and so on and so forth. If he got advice, he would have known that the letter that came out made reference to the particular claim that went in under the Industrial Relations Act 1969, which is essentially a trade dispute, and the letter would have had a box on it that you could tick, which would allow you as an employer not to let the WRC investigate the complaint at all, because it is optional, and any recommendation that comes from the WRC in respect of the Industrial Relations Act 1969 and a trade dispute, any such recommendation can simply be ignored. But it can't even be heard or dealt with or investigated in the first instance if the employer ticks the correct box on the form or on the letter that he receives, and that's the end of the matter. Instead, the employer came to me in an awful state of panic, stress, anxiety, loss of sleep and the whole lot. And this situation again could have been resolved very, very easily at the outset, because what he could have done was, when the employee came to him with issues or grievances, he could have simply given him the staff handbook and said, look, there's a grievance procedure or policy here in this handbook. please use this first, and then we'll try and sort you out and deal with the issues, and let that be the way that it was dealt with. And ultimately then, if it couldn't be dealt with internally, then it was open to the employee to bring whatever claim he wanted to bring. But the bottom line is, these issues and grievances were only issues and grievances. There weren't actually breaches of employment law, there weren't employment law breaches or breaches of employment rights. There were simply complaints or grievances, and the way to deal with them could have been internally through the grievance procedure, and a lot of anxiety, a lot of hassle, a lot of stress for the employer, and a lot of time and money indeed, could have been avoided if it was dealt with correctly. So, you know, I'm not saying for a minute that an employer should trivialise or not take seriously any letter that comes in from another solicitor about employment law breaches on behalf of a client. I'm not saying that any employer should trivialise or not deal seriously with any issues that an employee may raise, either through the grievance procedure or by bringing a complaint to the WRC. And I'm not saying that particular complaints cannot lead to expensive claims and costly claims, but I am saying that sometimes small employers who are not familiar with Irish employment law, who are not familiar with the Constitution, who are not familiar with EU regulations and the huge number of statutes on the Irish statute books in relation to employment law, sometimes the fear of God can be put in a small employer when it can be avoided. There's no need for it. It's unnecessary if they get decent advice at the outset and actually break down whatever claim there is into its constituent parts. I hope you find this video useful. If you do, you might give it a thumbs up down below, and you might be interested in subscribing to my YouTube channel. Thank you for watching.